Greetings and good afternoon. My name is Ed Steinfeld. I'm the director of the Watson Institute for International and Public Affairs at Brown University. Welcome, pardon me, to this very special event today, sponsored by the Center for the Study of Slavery and Justice at Brown and co-sponsored by Watson. But welcome to this very special event, a talk by my colleague and friend, Marcelo Ferraro, on the topic of slave resistance, criminal law, and regimes of racial violence in the Americas, Brazil, Cuba, and the United States, 1820 to 1850. This is such phenomenal work about such a phenomenally important topic. Let me just say a word about Marcelo Ferraro, a bit about his biography, and then Marcelo will speak for about 30 minutes or so, and then we'll open it up to Q&A from everybody in the audience. And I ask those of you in the audience, if you have questions and comments, when Marcelo is done speaking, just raise your hand electronically, use the raise hand function, and I will call on you to speak. Just a few words about Marcelo. Marcelo is a jointly appointed postdoctoral fellow with the Center for the Study of Slavery and Justice and also the Watson Institute here at Brown. Pardon me, Marcelo received his PhD from the University of São Paulo, Brazil in 2021, having previously received his master's degree in social history and his BA in history, law, and social sciences at the same institution. In 2019, he was a global fellow of the Weatherhead Initiative on Global History and a visiting graduate student of the Afro-Latin American Research Institute at Harvard University. Marcelo Ferraro is coordinator of Lab Mundi, Brazil in the World Systems Studies Lab at the University of São Paulo, and a member of the Global History Network. His first research project analyzed the role of architecture in a plantation society from southeastern Brazil, and more recently, he developed a comparative study on the intersections between slavery and criminal justice in Brazil and the southern United States. He's currently working on his book on slavery and racial violence across the Americas in the long 19th century, and that's the work that I personally learned so much from already, and that's the work that Marcelo will be presenting to us all today. Marcelo, with that, let me turn the floor over to you. And again, thank you and welcome.
Thank you, Ed, for that very generous introduction. Thank you, everyone, for being here. Good afternoon, everyone. I would like to thank Professor Edward Steinfeld for opening this event and for the opportunity to share my work. I would like to thank the Center for the Study of Slavery and Justice and the Watson Institute for International and Public Affairs. I've been developing this work since 2021, and it's been a privilege to be here at Brown University. I'm sharing my slides, so please let me know if you have any problems following this presentation. I could begin this conversation in a very formal way, talking about my book project, talking about my research, my investigation, but I decided to do it differently. I decided to begin with a reflection that might encourage you all to understand what are the objectives of this project. In the early 20th century, lynching in the American South became the main paradigm of racial violence in the Americas, perhaps in the world. The United States had been a slave country. Racism was the backbone of the society. However, other societies in the Americas were part of this legacy of colonialism and slavery. They were racist, and still lynching was not such an important phenomenon. A second thought here. In the early 20th century, Afro-Cubans organized the first Black political party in the Americas. And the Cuban state banned this political party, and the Cuban army massacred thousands of Afro-Cuban activists. State violence is a common phenomenon across the Americas, but state violence as the main form of racial violence was not that common in the United States by then, and it was not the same in other societies in Latin America. Finally, one last thought. Afro-Brazilians by then lived in an alleged racial democracy. Political mobilization, political organization was difficult for them, differently from Cuba. And at the same time, they were subjected to a brutal regime of violence, but it was not explicitly racialized. My question here, and I want you all to think about these questions during this presentation, is, If all of the societies were slave societies, if all of them were racist, why did they become so different? And why these regimes of racial violence, as I present here today, became so distinct in the Americas? I hope my research offers answers, possible answers to these questions. And also, I hope my research offers a historical understanding of the making of distinct racial regimes and distinct regimes of racial violence in the Americas, because right now, Afro-Brazilians, African-Americans, Afro-Cubans are fighting new regimes of racial violence, usually established by the state. We can talk about police brutality, we can talk about incarceration. If all of these subjects matter, then I think it is fundamental for us to investigate the historical making of these societies and the historical making of these present dilemmas. As I mentioned, my presentation is titled Slave Resistance, Criminal Law, and Regimes of Racial Violence in the Americas, Brazil, Cuba, and the United States between 1820 and 1850. This presentation is inspired by the second chapter of my book project. The book is provisionally titled Slavery, Citizenship, and the Politics of Racial Violence in the Americas, Brazil, Cuba, and the United States between 1776 and 1912. This long-during history of Atlantic slavery provides a new understanding of the origins of racial violence in the Americas. It begins by demonstrating how the expansion of slavery in the late 18th century influenced the making of constitutional regimes, criminal justice systems, and racial regimes in Brazil, the United States, and the Spanish Empire. Second, it presents changing patterns of Black resistance and legal and extra-legal violence throughout the long 19th century. Finally, this research investigates how the legacy of racism prevailed in the post-emancipation era within new repressive institutions and forms of racial violence. This comparative study often reviews a common past, but it also illuminates important distinctions. As I argue, racism and racial violence in the Americas were similar, but not the same. Scholars have long described how Anglo-Saxon and Iberian colonial legacies formed different racialized societies in the Americas. This investigation demonstrates that distinct ideologies, political systems, and legal cultures also played important roles in the formation of divergent racial regimes in the 19th century Americas. Therefore, despite the striking similarities between Brazil, Cuba, and the American South, each slave society created its own regime of racial violence. Today, I will present a few sections of Chapter 1 and Chapter 2 of my book project. We're talking here about Part 1, the Atlantic Regimes of Exception. Last year, I had the opportunity to share with the Watson Institute community and the Center for the Study of Slavery and Justice community the content of Chapter 1, Slavery, Race, and Citizenship in the Age of Atlantic Revolutions. By then, the title was a little different, but the same ideas were there. I apologize in advance for everyone who participated in those events, but I need to get back to some of this content to present the main conclusions of Chapter 2, Economies of Punishment and Regimes of Violence in the Frontiers of Slavery. My presentation is organized in 4 sections, 1 short introduction, 4 sections, and finally, a conclusion section. I will begin with a short introduction and then present the main argument of each section, beginning with a new age of slavery and race in the Americas. The Age of Revolution was a turning point in the history of Atlantic slavery. It initiated a first age of abolition in the Americas and at the same time, a new age for bondage in the United States, Cuba, and Brazil. Haitians moved beyond any previous experience of Black resistance in the Americas and set the precedent of an abolitionist slave revolution. This historical event had a major impact all over the continent. Free Blacks from Salvador to Havana radicalized their struggle for equality. Enslaved men and women from the Mississippi Valley to the Recôncavo Baiano now foresaw freedom as their right to vindicate. However, none of these rebellions achieved what the Haitian revolutionaries did. After all, they were not the only ones who learned from Saint-Domingue. Planters benefited from the economic collapse of that French colony and expanded new agricultural frontiers in Cuba, Brazil, and the American South. They were aware of the risk, but they turned the Haitian paradigm into the counterexample of their plantation societies and repressed anyone who intended to rehearse a new Haiti on their lands. At a key moment in their countries, this new generation of slaveholders and their political representatives influenced the making of constitutional regimes and their state repressive institutions. As I argue, at the turn of the 19th century, the greatest cycle of slave resistance in the Atlantic world contributed dialectically to the making of the strongest slaveholding classes in the Americas. Now I will present some of the content of chapter 1 of my book project, Slavery, Race, and Citizenship in the Age of Atlantic Revolutions. Here I would like to talk a little bit about constitutions, citizenship, and the making and remaking of racial regimes in the Americas. The constitutions of Brazil, Spain, and the United States created a political regime that overrepresented the slaveholding elites and made citizenship a privilege of class and race. However, each nation did it in their own way. The United States were a federal republic founded on racial segregation. Democracy was a white privilege, and free blacks were sub-citizens. In turn, Brazil was a centralized monarchy in which all free and freed people born in the national territory were citizens. Nonetheless, the Constitution established unspoken racial degrees of citizenship, preserving hierarchies between whites, browns, and blacks. A similar pattern characterized Cuban society in the early 19th century. And yet, local planters and their representatives in Spain decided to follow the example of the United States. They restricted the rights of free people of color and reinforced racial barriers through the law. Moreover, the Cuban elite abdicated from political rights and submitted to Spanish colonialism to preserve slavery and racial supremacy in their island. These constitutions and citizenship qualifications contributed not only to the preservation of slavery, but also to the making and remaking of racial regimes in the Americas. But there was a backlash. And this is what I call the dialectics of Black resistance. These political regimes were distinct but equally successful in legitimizing racial hierarchies and slavery. Dialectically, however, each racial regime caused specific backlashes. The increasing racial segregation in the French Caribbean was one of the causes of the Haitian revolutions by pushing free people of color to ally with the enslaved population against the whites. Such scenario was unlikely in the Anglo-Saxon Americas, where manumission rates were low and free communities of color comparatively small. Racial segregation prevailed, and Black resistance was essentially slave resistance in the American South. Cuban elites tried to reproduce the American racial regime on their island, but they faced strong resistance from a large established community of free people of color. Free and enslaved Blacks frequently joined forces to contest the island's racialized politics. The Brazilian racial regime was different, as was the country's pattern of subaltern resistance. Instead of the binary segregation between whites and Blacks, laws and local customs stimulated a hierarchical assimilation of free people of African descent. This system discouraged alliances between them and the enslaved population. In sum, people of African descent resisted captivity, disenfranchisement, and state repression across the continent. But the politics of Black resistance were different under each racial regime. This brings us to the core of the first part of this presentation, which is the making of criminal law in these slave societies. Slavery, race, and criminal law in Brazil, Cuba, and the American South. The constitutions had become a milestone of liberalism at the turn of the 19th century. They established the sacredness of individual rights, the sovereignty of the people through suffrage, and the principle of the rule of law. Just as important as any of those principles was legal control over state violence. The penal reform movement defended the reform of criminal law to establish rational legal procedures, criminal codes of law, and humane regimes of punishment. It was the birth of modern criminal justice systems and the penitentiary. However, how could there be a liberal criminal justice system in a slave country? I begin with the American answer. The Bill of Rights of 1789 established the principles of the reform of the judiciary in the United States. The amendments to the constitutions regulated due process of law, the right of criminal defendants to trial by the jury, and prohibited cruel and unusual punishment. These principles should guide the reform of legal and judicial institutions throughout the country. However, due to the federalist principle, each state assembly was responsible for reforming its own criminal justice system. Therefore, southern states created a dual legal regime. In court, every American citizen was protected by their constitutional rights and common law precedents. And yet, not all inhabitants enjoyed citizenship in the American South. Enslaved and free people of color were submitted to local slave codes, black codes, and special laws that established specific legal procedures and corporal penalties, a parallel system of justice. Now I would like to talk about the Spanish criminal law, especially in the Spanish Caribbean in Cuba. In 1811, the Cortes of Cádiz abolished Inquisition, torture, and the Cádiz Constitution prohibited torment in the Spanish territories. In the following decades, the criminal codes of 1822, and 1848 established the principles of a modern criminal justice system in the Spanish Empire, according to the penal reform movement. Yet, this legislation was never applied to the colonial military regime in Cuba. For most of the 19th century, Cuba remained under the rule of Spanish colonial laws. Moreover, the Spanish monarchy determined the creation of military commissions to try individuals accused of political crimes, and the Captain Generals of Cuba decided to include serious crimes committed by enslaved people under the jurisdiction of the special courts. Therefore, enslaved defendants never enjoyed constitutional rights and guarantees in Cuba, and neither did free people of color. They were tried and punished by colonial or military courts under the rule of laws inherited from the Spanish old regime. Finally, the Brazilian criminal law. The Criminal Code of 1830 and the Criminal Procedure Code of 1832 created a modern criminal justice system in Brazil and regulated legal forms of punishment according to the penal reform movement. Brazilians innovated by creating one criminal code that applied to free citizens and enslaved people all over the national territory. It regulated specific crimes and penalties for enslaved defendants. Meanwhile, the Criminal Procedure Code only differentiated free and enslaved defendants in a few articles, and it determined that all capital crimes would be submitted to jury trials. Therefore, enslaved defendants who were accused of homicide or insurrection would benefit from due process and legal guarantees. Yet, their fate would be decided by a jury of citizens, many of whom were white enslavers. After a wave of slave rebellions in the mid-1830s, National Congress reformed the criminal legislation and enacted the law of 1835, that established a special procedure that violated defendants' rights and accelerated the execution of capital punishment against enslaved convicts who were accused of attacking their masters and overseers. I'm sorry, so far this is a very long, boring, and technical presentation, but I need to get to these legal details to bring what I believe are the most important conclusions here. By the end of the decade of 1830, the penal reform movement had transformed criminal justice systems in the West, and nowhere did it fulfill the premises of preventing crimes and rehabilitating convicts. However, the contradictions between penal reform principles and the reality of criminal courts was explicit in the Spanish Caribbean, the American South, and Brazil, where slavery and racism were the backbone of the justice systems. Despite the specificity of each constitutional order, this nation established two regimes of justice. Civil rights and guarantees applied to citizens. Meanwhile, the rest of the population was stigmatized by race and enslavement and submitted to special laws. These legal regimes targeted Africans and their descendants as domestic enemies, subjected to a permanent state of exception under the rule of law. So I am trying to say that despite the differences between these political systems, legal regimes, for people of African descent who lived in these societies, enslaved or free, they were subjected to a permanent state of exception under the rule of law. This brings us finally to the content of chapter 2 of my book project, economies of punishment, and regimes of violence in the frontiers of slavery. Here I analyze the experience of people who were enslaved and also those who were manumitted, free people of color, in three of the most important agricultural frontiers in the 19th century Americas: the cotton frontier in the Mississippi Valley, the sugar frontier in Matanzas, western Cuba, and the cotton frontier in southeast Brazil, the Paraíba Valley. Well, at first, I was focused on the everyday life experience of these people on the plantations and the regimes of private violence that they were subjected to by their masters and overseers. But then I decided to investigate what happened whenever they committed a capital crime, a serious crime that should be punished not by masters and overseers, but by the state. Well, this is the interesting part of my research, because despite the differences that I presented so far, it seems that people of African descent suffered under similar regimes of violence. And this is not exactly true. I believe that violence on the plantation was similar in all three societies, but state violence and extralegal violence was different. And I believe this reveals important differences between these racial regimes and what I call regimes of racial violence. I begin this part of my presentation talking about the Mississippi Valley, the American South, slave courts and white terror in the Mississippi Valley. Here I analyze the German Coast Rebellion of 1811 and the panic, the insurrection scare of 1835. Unfortunately, I do not have the time in this presentation to talk about the episodes, but I hope you understand that I'm trying to reach the conclusions of how these slave communities punished and repressed enslaved rebels. The American Constitution determined that violence was an exclusive attribute of the state, but slave and black codes legalized slaveholders' right to punish. When the enslaved committed serious offenses, they were tried by slave courts, an assembly of freeholders, an improvised jury, and a justice of peace, or eventually by the jury. This was the case in Mississippi. And they suffered corporal penalties or capital punishment, usually by hanging. Charles de Lont was the leader of the German Coast Rebellion. After rebels were defeated, he was summarily tried by a slave court and sentenced to death by burning. This was essentially a lynching under the rule of the Louisiana Black Code. Although this was a severe punishment, it was technically legal. However, a few capital crimes like insurrections and the alleged rape of white women violated crucial norms of the racial order and encouraged white communities to dismiss the rule of law. Insurrection scares like the Panic of 1835 were particularly revealing. On some occasions, rural elites conducted extralegal investigation with the connivance of public authorities and preserved social hierarchies. Planters interrogated and punished conspirators on their plantations, and prestigious citizens and authorities formed vigilance and safety committees to promote extrajudicial trials with some formality. Still, mob violence and mob justice, as they would say, often prevail, especially when whites suspected that black conspirators threatened their racial and sexual privileges. And here I present one important conclusion. The lynch law was not only the consequence of racial slavery, it was also the other face of white democracy in the American South. In the decade of 1830, the expansion of citizenship and political rights to poor whites reinforced racial alliances that contributed to the preservation of the hegemony of the planter class. At the same time, common white men felt encouraged not only to vote and serve as jurors, but also to take justice into their own hands. In conclusion, violence was theoretically a state prerogative and a class privilege, but in practice it was often exercised as a democratic right of the white race in the American South. Now I would like to talk a little bit about the Brazilian experience. Here I analyze the Manuel Congo Rebellion of 1838 and the conspiracy of 1848. Insurrection was a capital crime, and enslaved defendants were tried by the jury under special laws that reduced their rights in court in Brazil. This was the fate of African rebels like Manuel Congo, who faced trial and the gallows in Vassouras. These events illuminated the contradictions of the rule of law in the slave society, but alleged conspiracies were even more revealing. In most cases, suspects were subjected to extralegal violence, but rarely mob justice. Differently from the American South, racial solidarity among planters and poor whites was not a premise of the slave order in Brazil. The Constitution and citizenship regime established social degrees of race and status that discouraged alliances between the free and the enslaved, browns and blacks, Brazilians and Africans. At the same time, criminal law legitimized the enslavers' right to punish, and they rarely shared this prerogative with their free subalterns, most of whom were not even white. Their planter class was also politically influent and restricted the intervention of the state in their private dominions. This was especially true during insurrection scares like the conspiracy of 1848. Enslaved people who committed capital crimes were tried by the jury and usually sentenced to death by hanging, but alleged conspirators were subjected to a parallel system of justice conducted by planters with the connivance of public authorities. These proceedings reveal, and this is my conclusion here, these proceedings reveal that Brazilian planters were more powerful than their peers from the American South, and also from Cuba. They often subordinated judicial and police institutions to their interests and preserved the right to punish as a privilege of their class. Finally, the Cuban experience, military courts and state terror in Matanzas. Here I analyze the Guamacaro Rebellion of 1825 and the conspiracy of La Escalera. Nowhere else in the 19th century Americas, slave rebellions were as frequent as in Western Cuba. The same applies to alliances between free and enslaved people of African descent against racial oppression. Under the Spanish colonial regime, free whites and blacks did not enjoy most constitutional rights, but the planter class benefited from a few political privileges and the prerogative of domestic violence. Alongside with colonial authorities, they established a brutal system of surveillance and punishment in the island. Free people of color were subjected to repressive racial policies, while the enslaved lived in a permanent state of war. Consequently, they often united to confront the ruling race. Black rebels were tried by military courts and condemned according to colonial laws. Some of them were imprisoned or exiled, others were hanged or garroted, and the most subversive faced the firing squads. The spectacles of violence were revealing moments of the Cuban racial regime, and so were insurrection scares. During La Escalera, planters conducted extralegal investigations and executions on the plantations, and there were episodes of collective violence against Black suspects. However, the legitimacy of this regime of racial terror depended on the sanction of the state, who was responsible for the torment of thousands of Afro-Cubans during the racial purge of 1844. And here is my conclusion about this case. Cuban planters were not as powerful as their peers from Brazil, and mob justice was not as recurrent as it was in the American South. Threatened by the most formidable wave of Black resistance, the preservation of racial order in Cuba relied on a regime of exception based on the prerogative of violence of the Spanish military state. I don't know if things are clear so far, so I just want to summarize part of this investigation. In my research, I investigated slave rebellions, which were crimes tried in court and punished under the law. This was the case of the rebels from the German Coast Rebellion. They were tried by slave courts and sentenced to death by hanging, perhaps burning. Some of them had their heads severed and exposed on poles. All of this under the rule of law, although there is a limit of the rule of law in this situation. Rebels from the Manuel Congo Rebellion were tried by the jury. Most of them were sentenced to corporal punishment, and only Manuel Congo was sent to the gallows. Rebels from the Guamacaro Rebellion in Matanzas, they were tried by military courts and sentenced to death by hanging, garrote, and some of them killed by firing squads, a military technology of punishment. These differences, they are connected to the distinction between these political regimes, these different legal systems. But I believe that the most interesting information I found was about slave conspiracies, because they are the intention of committing a crime, and most proof against conspirators was obtained under torture, so it was not valid in court. So these societies punished conspirators outside the rule of law. We are talking about different regimes of extralegal violence, and they were so distinct that I believe they revealed the essence of distinct racial regimes and regimes of violence in the Americas. The alleged conspirators during the Panic of 1835 in Mississippi, they were tried by vigilance committees, an improvised committee of citizens. They were summarily tried, executed, and many were murdered by mobs, hanged by mobs. During the conspiracy of 1848 in Brazil, most conspirators were punished by planters on the plantations. In the meantime, the conspiracy of La Escalera was an opportunity for the Spanish military government to promote a racial purge in Cuba. The state was responsible for punishing conspirators. How can we understand these differences? I finally arrived to the conclusion of this presentation: regimes of racial violence. The preservation of public order in enslaved societies demanded special laws and legal procedures that compromised the rule of law principle and transformed the justice systems into instruments of racial order. In these countries, the constitutional prohibition of cruel punishment did not apply to enslaved convicts who were submitted to a variety of corporal penalties. Despite the alleged modernization of criminal law, these modern spectacles of violence revealed reminiscences of the old regime and the prevalence of racialized justice systems. Yet, there were important differences between these regimes of legal and extra-legal violence, as slave conspiracies reveal. Each country had their own justice system and technologies of punishment. Furthermore, violence was more explicitly racialized in the United States and in Cuba than in Brazil. At the same time, mob violence was more common in North America than in Latin America, and the state was more violent against Blacks in Cuba than anywhere else. These differences were the consequence of the making of distinct racial regimes. They originated in the colonial era and changed under new political systems, regimes of citizenship, and racial ideologies during the 19th century. Democracy and white supremacy in the United States encouraged the common white man to volunteer as jurors in court and conduct parallel forms of justice like lynching. In contrast, the Brazilian monarchy reinforced oligarchical powers, and extralegal violence was rarely a mob action. The prerogative of violence and justice was essentially a privilege of the planter class that was predominantly white and subordinated free and enslaved people of color. Finally, the presence of a colonial military government reinforced the state prerogative of violence in Cuba. Slaveholders were the main authorities on the plantation, but the preservation of the racial order depended on the Spanish imperial state. In sum, and this is my definitive conclusion here, the right to punish was simultaneously a state prerogative and a privilege of class and race in all three societies. I will repeat that. The right to punish was simultaneously a state prerogative and a privilege of class and race in all three societies. However, there was a hegemonic source of power and legitimacy in each regime of racial violence: the white race in the democratic American South, the planter class in monarchical Brazil, the Spanish state in colonial Cuba. These constitutional regimes and modern justice systems extended legal rights and guarantees for their citizens, while thousands of free and enslaved men and women of color lived in a permanent state of exception. For them, all regimes of racial violence were violent and racist, and the exception was the norm. Thank you.
Thank you so much, Marcelo, for that really extraordinary presentation and just phenomenal research. Let me open it up now to the audience, and I invite you all to ask questions or offer your comments. Please do so by raising your hand digitally, just clicking on the reactions button at the bottom of the screen, and I will call on you in the order that I see hands. So Michael Becker, I see you have a hand up. Why don't you go ahead and ask?
Excuse me. Thank you, Marcelo, for a really engaging, interesting presentation. I noticed as you're talking about regimes of racial violence, your analysis in the presentation focused on responses to conspiracies and rebellions. And I'm curious, what, if any, differences might we notice if we think about more quotidian prosecutions, shall we say? So, individual murder cases, individual cases of fugitives being pursued by the court, etc.
Michael, thank you for your question. And this is a very generous question because in this presentation, I talk about conspiracies and rebellions, but just to make things a little more clear, in the book itself, I analyze everyday life on the plantations, and I also analyze common crimes like the murder of overseers and masters. And in these cases, yes, there are important differences, but most differences are connected to the distinctions between legal systems, the distinctions between political systems. So in most cases in Brazil, people, enslaved defendants who were accused of capital crimes, they were tried by the jury, usually sentenced to death by hanging. Sometimes they were sentenced to perpetual galleys or corporal punishment. And there are this is something tricky to get into, but depending on the political environment of each period, the death penalty was executed more frequently. So it's not only about the legal system itself, it's also connected to politics. Whenever something similar happened in Cuba, they were usually tried by military courts, the military commission, and they were executed, but not by firing squads. Firing squads were the technology of punishment for rebellion, usually. And in the United States, slave courts had a lot of freedom. Most of the time, most people who committed capital crimes in Mississippi or Louisiana, they were tried by slave courts. In Mississippi, they were tried by the jury, and they were sentenced to death by hanging. But slave courts, this very improvised jury, they had a lot of, they had the prerogative of deciding what punishment suits better each situation. So eventually they decided that the defendant, the convict, should be executed by burning. So there are important differences, but I believe that those differences reveal more about the distinctions between these legal regimes and political systems in all three societies. I hope I answered your question.
Great, thank you. And I would encourage more people in the audience to ask questions and offer their comments. But I have a few questions of my own, if I can take the liberty of asking. One question involves how these regimes of punishment and violence changed, if at all, not so much the present, I have questions about that too, but even moving through to the 1920s, say, the end of your study, Marcelo. So how did the regimes change, if at all, after abolition, but through, say, 1920?
This is a very good question, Ed, and this is what I will try to answer by the end of my book, because I want to understand how the legacy of slavery, the legacy of racial slavery, the legacy of these racial regimes in the 19th century, how it is connected to the regimes of violence of the 20th century. I began this presentation talking about lynching in the American South, but I could talk about the 1912 massacre in Cuba and other experiences of violence in Brazil. So this is what I intend to be the conclusion of my book. What I believe is that emancipation, the abolition of slavery, changed the status of people of African descent in this continent. And at the same time, they did not allow that planters had so much power to control the Black communities in rural areas like the Mississippi Valley, the Paraíba Valley, and Matanzas. However, they still had some kind of prerogative, even though they could not use legalized regimes of violence, they could use other forms of violence that were not that explicit. What I believe is that in the 20th century, despite the experience of lynching in the American South, which is very specific, the state became the most important institution in monopolizing violence. So if we think about the 21st century and these regimes of violence nowadays, we're usually talking about regimes of racial violence based on police institutions and incarceration. So what I believe is that after emancipation, the main differences between regimes of racial violence, what is new is that the state becomes more important in this process of establishing a monopoly of violence, and in this case, a monopoly on racial violence in the Americas.
Got it. Thank you. And now I turn to my colleague and the director of the Center for the Study of Slavery and Justice, Professor Tony Bogues.
Thanks, Ed, and thank you very much, Marcelo, for really carefully thought out research presentation. Thanks a lot. One, I am trying to work through a distinction that appears in your talk between the state, plantations, wherever they are, and the kind of customs and laws that would govern plantations and the relationship between the enslaved and the planter. Because I'm trying to wonder whether or not those codes and customs themselves are not part of a general state apparatus, or part of a certain kind of state repressive apparatus in which one deals with the government of the ruling over slaves' bodies, and therefore enslaved bodies and violence. So that's my first thing. So the distinctions you are making, I'm finding interesting, but I'm then trying to think about, okay, that those distinctions can only be construed, can only be implemented and become real with state support. If there is no formal state support, then it doesn't happen. So I want to ask you if you could talk a little bit about that. And then secondly, I wanted to ask you, and I think it's really great that, the argument about exception is that, the exception was the rule, which knocks out a lot of the arguments in political theory about states of exceptions and so on. But I want to then ask you the question that if exception was the rule, then what can we call these so-called constitutional regimes as they enacted repressive rule against enslaved bodies? And thanks again for the presentation.
Thank you, Professor Bowles. These are beautiful questions, and they focus on the theoretical basis of this research, and I appreciate the opportunity to talk about this. First, I would say that definitely we cannot really separate the state, the law, and what is happening on the plantations, because if there is a hegemony of planters in these rural areas, in these frontiers of slavery, it is only because the state, the law, are offering legitimacy to this people. Whenever planters cannot control the enslaved populations, of course, the state is always there behind their back to support the preservation of slave order. What I try to do is I try to understand why is it that the state is more present in some occasions than others, and why is it that this relationship, this complicated relationship between planters and the state is different in each society. In my research, I use a concept that is the oligopoly on violence, or the oligopoly of racial violence. Of course, most of you are familiar with the Max Weber definition of the state as the monopoly on violence. And of course, this is an abstract principle that should guide society. No society has established an absolute monopoly, a state monopoly on violence. But in slave societies, there is a specificity because violence is, by definition, by law, it is a prerogative, both of the state and planters. And what is interesting to analyze is that this oligopoly on violence, so this alliance between planters and the state to preserve slave order, this is fundamental in this society. But there is also a lot of tension because whenever the state is the one punishing the enslaved, they're also interfering with private property. So this oligopoly on violence is not only an alliance between planters and the state, there is also a lot of tension between this ruling class and state institutions. What I try to understand is, yes, the state is fundamental for the private preservation of order on the plantations. But how this connection between the state and planters changes from one society to the other and changes through time. This is something I did not have the time to talk here, but in my research, I demonstrate that these tensions between the state and planters, they also changed in the early 19th century comparing to the late 19th century. So I'm just letting you know that I'm thinking about the role of the state, even when I'm talking about order on the plantations, and I'm thinking of the state and planters, and I know about their connections, but I'm also trying to understand how each power institution adapts to each specific society and time. And your second question, it's a beautiful question when we're thinking about like, if the exception is the rule, if we're thinking about the rule of law, democracy, and we are saying that the exception is the norm, so what is actually a constitutional regime? My perspective so far is that constitutional regimes and the rule of law are not a lie, but they are a class or a race privilege. Citizens are the ones who enjoy this language of rights. They are the ones who enjoy what constitutional regimes supposedly offer the entire society. So I do believe that the definition of constitutional regimes or the rule of law, they are important because they define how the state deals with part of the society. What is interesting is to understand who are the ones who are selected as citizens and the ones who are preserved under a state of exception. And here I am influenced by the work not only of Giorgio Agamben, but especially Achille Mbembe, and the idea that part of the society usually stigmatized by race is not considered citizens, they do not have rights, and they are subjected to a permanent state of exception under the rule of law. So thinking about constitutional regimes, rule of law, and a permanent state of exception, I think this contradiction is fundamental to understand differences between people in society, and usually differences that are established by race.
Okay, thanks.
Thank you, Marcelo. There's actually a question that came in via the chat. If it's okay, I'll read the question. This is a question from Lucas Brison. Apologies if I've mispronounced anybody's name. But Lucas writes, congratulations on the presentation. I'm very excited to read your book. My doubt follows on the question about the multiple processes of racial identification, especially in Brazil and the United States. I don't know enough about Cuba. In this case, how did the miscegenation built in each country enable particular forms of notions of citizenship and the way in which this affected criminal laws in each region?
Lucas, this is a very good question. And of course, this comes from a Brazilian scholar, because if we're thinking about race in Latin America, we're not talking about the binary paradigm of North America. We're not talking about the one-drop rule. We're talking about mixed societies, and self-identification is important and how the state deals with the self-identification. What I tried to do in my research was to understand how these different racial regimes, they organize distinct criminal justice systems. So I might say that in the United States, most criminal justice systems, in the American South especially, they targeted Blacks as the ones who should be subjected to special laws, slave codes, Black codes. This was not the case in Brazil. In Brazil, the law, there is a long tradition of legal silence on race in Brazil. And I do analyze not only miscegenation, but the fact that the law in Brazil is not explicit about race. However, it is fundamental to go beyond the law when we analyze the Brazilian society. We need to understand that the making of race does not depend on the law. And there were other instruments of targeting people of African descent as the one who should be subjected to specific legal procedures. And the law of 1835 is one example in Brazil. We could have a long discussion about the differences between racial regimes, but if I want to talk about the intersection, about the distinction between racial regimes and the distinction between criminal justice systems, I think this is the most important one.
Thank you, Marcelo. And now, Michael Becker, you have another question. Go ahead.
Thank you. I just had a brief follow-up comment on this question about the how do we think about the relationship between the planter class and regimes of violence on the plantation and the state. And as you were talking through that, I was actually thinking quite a bit about Diana Payton's book, No Bond But the Law, looking at the development of the workhouse in Jamaica. And I think one of the interesting points that she makes to great effect is that the state apparatus has many sort of competing components. In the Jamaican case, there's interests of the imperial government in London. There's the interests of the absentee planters. There's the interest of those that are actually serving in the Jamaican Assembly, and of the bureaucrats by the colonial governor who are sent over from the UK. And so she actually traces out in some detail how sort of fissures and fractures among that ruling class are really important to how the apparatus of criminal justice and the development of technologies of incarceration changed between about 1780 and 1870. So just a thought that might be helpful to look at.
Michael, that comment is great. I really like Diana Patton's work on Jamaica, and I think it is interesting that you bring, like, we should think about the state not as a unity, but thinking about these competing components of the state itself. This is particularly interesting when we compare different political systems and different legal regimes, because it is one thing to talk about the state in federalist American South. It is different to talk about the state in monarchical Brazil. Power is much more centralized in Brazil. And at the same time, in rural areas, planters are very powerful to subordinate these public authorities who work there. Cuba is different. We're talking about a colony in the 19th century. So I'm just saying that your comment is perfect, because although I try to bring this very strong conclusions about the state, class, and race, I'm aware that there are many specificities for each legal regime, each political system. And I try to do that in the book. I think in presentations, we need to aim for strong arguments so that we can encourage discussion.
Thank you, Marcelo. I think we have time for one or two more questions. So I would again urge people in the audience, if you have comments or questions, to please jump in while there's still some time remaining. But again, I'll exercise the privilege, or abuse the privilege, of the moderator to ask another question. Marcelo, my understanding of your work is that your argument is, at least in the 1830s, the regimes of violence developed as sort of a rational response to the threat of insurrection. Whether, of course, we don't justify this, but that there's a fear of insurrection and hence a response. And I wonder, first, is that the accurate reading? Am I right? And moreover, is there change over time? And what kind of change from a kind of quote unquote rational institutional response to a threat to some other function that these regimes of violence are playing, when rebellion is a more distant issue in the past? Maybe it's not a viable threat to society, but these regimes of racialized violence persist. And I wonder whether that's true, and how, to what extent those regimes are morph and start serving other social functions across these societies.
Ed, thank you for this question. It gives me the opportunity to talk a little bit about the new steps of this project. So first, yes, there was a wave of insurrection since the late 18th century and the 1830s. There's a second wave of insurrections. And this definitely encourages a response from statesmen, from public authorities in all three societies. So we can think about a rational institutional response by the state. And this is what I analyze in chapter 1 of my book project when I talk about the making and the reform of criminal law. But this is one thing. This is the political response. This is the rational response. But when I talk about regimes of racial violence, I'm not only talking about the state formal response to the event, I'm actually talking about things that are happening beyond the control of the state. And this is interesting because although, for instance, American criminal law in the American South, there is like planters, public authorities, they have a lot of freedom to conduct the slave courts. And yet mob violence is recurrent in the society despite this. And it's not because the state is not there. This has to do with other dimension of this racial regime. So I do think about the rational institutional response, but I also talk about regimes of racial violence that have to do with more structural conditions of the making of racial regimes. We can talk about different sexual cultures when you think about the alleged rape of white women and lynching in the American South. We can talk about the role of the state in Cuba. So I'm trying to do both. And second, yes, when we analyze these regimes of racial violence through time, we can see that they do change. In the early 19th century, the state was very present and the death penalty was an instrument of the slave order. This changes in the mid-19th century because of the penal reform movement. The slave societies are trying to legitimize themselves internationally, and they need to prove that they are civilized nations. So the death penalty is not executed that often. But then in the second half of the 19th century, there is a new wave of slave rebellion, of Black resistance in the Americas. And then there are different responses in each society. The death penalty is executed once again in the American South very frequently. And this has to do with the federal system. This has to do with democracy. In Brazil, the death penalty is almost abolished. And it's abolished because of a decision of the emperor and some people who participate in the core of the Brazilian monarchy. In Cuba, it's different because sources are not that explicit, but the death penalty is not executed that often. And this is something that I don't have the time to develop, of course. But mob violence becomes recurrent in Brazil and Cuba for a while. But then after emancipation, this type of mob violence that was very common in the American South once again becomes an American experience, and it disappears from Cuba and Brazil. And what I try to do in the second part of my book project is understand that although there was an experience in which extralegal violence looked the same in all three societies, emancipation is the beginning of a new age, not only a new age of race, but a new age of racial violence in the Americas.
Thank you, Marcelo, for that extraordinary answer. We have time just for one last question. We have one more that came in on the chat. So this is a question asked by Najira Knott. Again, apologies if I've mispronounced anybody's name, but I'll read the question. Najira writes, my question is, in the beginning of the presentation, Marcelo mentioned how Africans and people of color were subject to legal exceptions. How does this apply when looking at it retrospectively in the context of issues like racial violence, for example, police brutality today?
This is beautiful. Thank you so much for this question. When I talk about regimes of exception under the rule of law, I am not talking about the past. I'm talking about the present. So when we think about police brutality and incarceration, targeting people of African descent in Brazil, the United States, and even in Cuba, although mass incarceration is not a good concept to talk about Cuba, we are talking about citizens who are not treated as citizens. So they are subjected to legal exceptions, although we lived in alleged democracies in the 21st century. What I'm trying to do, I'm trying to take steps back to understand that the origins of this permanent state of exception, the origin of these regimes of exception, is connected to the formation of these constitutional regimes from the beginning, and different regimes of citizenship and different regimes of race. So since the colonial period, and especially in the early 19th century, The transformation of these societies, the transformation of these racial regimes, and the making of constitutional regimes from the beginning was based on a segregation between those who were citizens and those who were not. And if nowadays we are talking about people of African descent who suffered under regimes of exception, under the rule of law, we're talking about something that has a very long history. Police brutality and incarceration are just a new phase of something that began a long time ago. Of course, it begins in the colonial era, but I believe that the 19th century is the most important historical moment to understand how we got here.
Thank you so much, Marcelo. We are unfortunately out of time, but I want to thank everybody in the audience for your participation. I want to thank the Center for the Study of Slavery and Justice and its staff for making this event possible. And of course, Marcelo Ferraro, I want to thank you for educating us and enlightening us and making us hungry to learn more from your ongoing research. Thanks, everybody.
Thank you, everyone, for being here. I would like to thank everyone from the center, Tony, Kiko, Shana, Africa. I would like to thank Ed and everyone who could be here today. I appreciate it.
Thanks.